Good morning, good afternoon. Welcome to this webinar. We are going to start in a few seconds. Welcome.
Good morning from our side as well. Good morning, good afternoon, and maybe good evening or good night.
Yeah, we have people joining from everywhere. So we are going to start. I am Fanny Destug. I am the Director General of CICA, the World Construction Association representing the contractors associations at the global level. We are very pleased to continue our collaboration with FIDIC for this second webinar series. At CICA, we are truly committed to promote the use of internationally recognized, fair and balanced conditions of contracts. In particular, at a time of geopolitical uncertainties, limited financing for the projects, which tend to be more complex with high quality requirements. We are also committed to sharing best practices and experiences about how to use contracts as tools to de-risk the projects. Today, we will discuss the role of the engineer, and we are honored to have had more than 1,000 registered participants for this webinar. We will have a second webinar about the Emerald Book on the 25th of June, and a third one on the good preparation of construction projects, a topic dear to our hearts, on the 1st of October. We already have a great lineup of speakers, and we hope you can join us for those next episodes. As we like the webinars to be interactive, please use the chat to type your questions. Do not hesitate to participate and ask the questions to our speakers. We will make sure to save time for the discussion. Finally, before I leave the mic to Daduna, I want to warmly thank Daduna, Yeva, and Andine, the task force behind these webinars, and of course our speakers who will be introduced in a moment. So I hope you all have a nice time with us today and that you enjoy this webinar. Thank you. Daduna?
Thank you so much, Fanny, for your kind introduction and for a warm welcome. A warm welcome from me as well. I'm Daduna Kohreidze, FIDIC's Chief Legal and Contracts Officer, and it is a true pleasure to co-moderate this webinar with you and a true pleasure to collaborate with CICA. I'm delighted to have so many participants registered today from all over the world and truly excited about our stellar panel who will be sharing their expert insights throughout the webinar. Today's session explores the topic that sits at the core of successful project delivery, the evolving role of the engineer under the FIDIC suite of contracts. We will look at how effective engagement between the employer, the contractor, and the engineer improves risk management, helps reduce disputes, and ultimately leads to better outcomes for clients and the communities these projects serve. The topic is central to the ongoing collaboration between CICA and FIDIC, as both organizations are committed to promoting balanced contractual practices and strengthening project performance globally. Before we move into the topic discussion and before I introduce the speakers, I would like to also take this opportunity to highlight the recent publication of FIDIC's Carbon Management Guide and Carbon Emissions Management Guidances, which represents a major step forward in supporting decarbonization across our industry. The guide provides practical tools and mechanisms for managing carbon across the entire project lifecycle, from procurement all the way to decommissioning. The guide and the CM guidances are now ready to be explored, to be considered, and to be used on projects by our industry. So please take a look and please share your thoughts about the guides as well and how we can move forward in decarbonizing the industry. With that, I would like to start introducing our speakers. And I'm extremely delighted that we have FIDIC President Alfredo Incletti joining us today to share his insights with you. Alfredo is the co-founder, chairman, and technical director of 3TI Progetti, a multidisciplinary engineering consultancy established in Rome. He has over 35 years of experience in architectural, infrastructural, and structural design, as well as project management across both domestic and international markets. Alfredo has held significant institutional roles within OICE, the Association of Italian Engineering, Architecture and Technical Economic Consultancy Organizations. In September 2025, Alfredo has been elected as FIDIC president. Alfredo, thank you so much for joining us. I will introduce the next speakers and we will pass the floor to Alfredo. Our next speaker is Ellis Baker. Ellis is the Global Head of Construction Practice at law firm White & Case and is an author on construction law. He is one of the few individuals ranked Band 1 for construction, contentious and construction, international arbitration by chambers. He is also ranked in the Hall of Fame for construction by Legal 500. Ellis is the lead author of FIDIC Contracts, Law and Practice, published by Routledge, the principal construction textbook covering the whole suite of major FIDIC forms of contracts. Ellis, thank you for joining us. Our next speaker is Husni Madi. Husni is a member of the FIDIC Contracts Committee and acts as an international arbitrator, dispute board member, adjudicator, and mediator. Husni has over 27 years experience. He's a civil engineer qualified in law with LLM in construction law and arbitration, and he serves on major institutional and ad hoc arbitration tribunals. He's a fellow of a CIR, a FIDIC certified adjudicator on the FIDIC's president list, and he's also an internationally accredited FIDIC trainer. In addition, he is active in leading professional bodies, including the ICC International Center for ADR, and he lectures at the university in Germany. With that, Fanny, I would like to hand to you to introduce our next two speakers before we start the panel discussion.
Sure, I'm very pleased to introduce Lidis Campos. Lidis Campos is a qualified lawyer specialized in construction law with over 17 years of international experience across countries in the Americas, Africa, and Europe. Lidis is currently senior legal counsel at B6 for international projects. Her previous roles include leading major claims and contract management. Thank you, Lidis, to be with us today. And then we also have Jonathan Turgi. Jonathan has 21 years experience in mobility infrastructure, 15 years with Sistra, a mobility global engineering company. He leads Sistra's works with international financing institutions and institutional partners and draws on hands-on project implementation experience, notably in Latin America. Jonathan also serves as chair of Syntec Ingénieurie's International Commission and is a member of FCA's External Action Committee. Thank you, Jonathan, also to be with us today. I will now turn to Alfredo Ingletti, as we are very honored to have with us the president of FIDIC today with us. So, Alfredo, as president of FIDIC, could you elaborate on the role of the consulting engineers in delivering sustainable infrastructure?
Thank you, Fanny. Thank you, Daduna, for your kind introduction, and thank you, everyone, and welcome to this first episode of the series of webinars. I was reflecting today, we have a very qualified speakers that can drive you through all the details of the role of engineer in the FIDIC contracts. But as I'm starting this discussion, I would like to reflect around the title of this episode, the role of engineer. And I was reflecting about the definition of engineer in FIDIC contracts and the definition of engineer in our profession, in our industry in general, no? And this is very interesting that this coincidence between the name of engineer as a profession, I feel myself as an engineer, and the role of engineer. It is interesting that FIDIC contracts suite and framework elaborate this name as the most important precisely on the quality of contract delivery, on quality of all the activities, and to witness the quality of every one of the actors of the process. This is, in my opinion, very important. And this is something that I feel as a legacy from the old tradition of our industry. You know, Daduna said that I'm coming from Rome. I'm speaking from Rome, and we feel as the first engineers in the history, because all the practices that were developed in the ancient roads, monuments, aqueducts, and everything else is still in our new infrastructure. And as well as in the ancient time, engineers are the responsible of all these changes in the world. Now, I'm used to say that we have a great responsibility. We turn vision into reality, the vision of projects into reality of infrastructures. And this is a great responsibility for the engineers, and we feel it strongly on our shoulders. And being FIDIC the most comprehensive representative body of engineers, I think we are in the right place to deploy our capabilities on projects. And this is at the end, by, let me say, a philosophical way of saying the role of engineers on the projects, to be the responsible of the quality of the projects. And in my opinion, this is a crucial role that cannot be avoided in the construction of a project. Is someone, is a team, normally is a team, that is between all the actors, the stakeholders, the construction companies, the designers, everyone is around the project and the delivery of quality of the projects. Look at the engineer has the let me say the polar star, no, the one that can give the right advices, that can avoid disputes, that can direct the project decision, and they support the decision making process around all the life of the projects, and probably beyond the end of the projects, with the phase of usage of the infrastructure. So by this way, I think it's very important, and today is going to be a great opportunity to fully analyze the roles and responsibilities of the engineers, but at the end, from my point of view, to remember that the engineer is a crucial point in the delivery of an infrastructure, and needs to stay and to be supported, and to support all the actors of the process in making an infrastructure. And this is the approach that we have at FIDIC, to be to serve the project with our capabilities, and to support and advocate for our principles, quality, integrity, and sustainability. And this is all put all together in our strategic plan, where we say engineering a bright future together. And I would like always to put the accent on the word together, because this is the real aim of engineers, and also of the engineer in a FIDIC contract, in my opinion, to put all working together and for the quality of the project. I don't want to take more time for my introduction, because we have a very, very full agenda, and I think that's my thoughts about the role of engineers, and I go ahead listening to our speakers and their interesting presentation. Thank you, Fanny, and back to you.
Thank you so much, Alfredo.
Or
it's truly
Daduna, sorry.
we will be stepping in, me and Fanny, from time to time. Thank you so much. It's truly an honor to have you here. And thank you to you and to all the engineers for turning vision into reality, as you said. That's very important. And of course, the collaboration for engineering bright to future together, and collaboration with CICA is one of the examples as well for working with the industry associations. But thank you so much, Alfredo. I'd like to now open a panel discussion and turn to Ellis from the high level and very interesting perspective of from a FIDIC president about the role of the engineer in the industry and historically. Now to turn to you to ask you to describe the fundamental role of the engineer under the FIDIC suite of contract. What is the role that the engineers under the contract have?
Thank you very much, Daduna. Good morning, good afternoon, and good evening, ladies and gentlemen, wherever you may be. And I can see from the chat that people are listening in from all over the world, which is a wonderful thing to have indeed. Perhaps we can have the first slide, please. The next slide can be put up.
This is my slide. I'm already sharing.
Ah, yes, but can we have the next slide, please?
Oh, okay, thank you. I'm on the slide on origins of the dual role.
It's not changing.
It's not changing. The slide isn't changing. So we need the next slide, which is called the engineer in the red and the yellow books.
This slide looks so beautiful, Alice, that it doesn't want to change.
Doesn't want to change. Well, perhaps whilst the slide is being sorted out, perhaps I can just start by making a few introductory remarks. And so the starting point for this discussion is that the engineer is selected, appointed, and paid by the employer under a consultancy agreement entered into between the employer and the engineer. And the engineer, however, having said all of that, has wide powers under the building contract. And of course, the building contract is to be entered into between the employer and the contractor, whether that be under the FIDIC Red Book, where the works are designed by the employer, or under the Yellow Book, where the works are designed and constructed by the contractor. And it is the exercise of these powers that is the subject of this webinar. But one must ask at the outset, what qualifications are required of a person acting as the engineer? And that is specified in subclause 3.1 in the Red and the Yellow Books 2017, which provide that the person who is acting as the engineer must be a professional engineer having suitable qualifications, experience, and competence to act as the engineer under the contract. The contracts also provide that the engineer must be fluent in the ruling language of the contract. Now, these wide-ranging powers of the engineer under the Red and the Yellow Books fall into two different categories. Or to put it another way, the engineer has a dual role under these contracts. And the first of these roles is where the engineer acts on behalf of and as the agent of the employer. And in the second of these categories, the engineer acts as a neutral decision maker, making decisions that are binding upon both the employer and the contractor. Now, this dual role of the engineer is based upon the role of the contract administrator, described variously as the engineer or the architect under the English standard forms of construction contract, upon which the FIDIC red and yellow books are ultimately based. And I note in this regard that FIDIC's first construction contract, the Red Book of 1957 for works of civil engineering construction, was modelled upon the then current version of the English contract for works of civil engineering construction, published in 1955 jointly by the English Institution of Civil Engineers, the Association of Consulting Engineers, which is FIDIC's UK member association, and the Federation of Civil Engineering Contractors, which is now the UK Civil Engineering Contractors Association. And against that background, it's helpful when considering the role of the engineer under the current red and yellow books to have regard to the English law governing the role of the engineer and the architect. And the leading exposition of this role is in the English case of Sutcliffe and Thakrar, which was decided in 1974. So perhaps you could have the next slide now, please. I think you've missed a slide. We have slide 5, please. Thank you. Right, and you can see on this slide, I have set out some of the extracts from the judgments in that case. And it's worth just spending a moment on that. So if one has a look at the first paragraph, where the judgment refers to 2 different types of function to perform. Then the next sentence goes on. In many matters, he is bound to act on his client's instructions, whether he agrees with them or not. And that is the agency role that I've just been describing. He then goes on to say, but in many other matters requiring professional skill, he must form and act on his own opinion. And that is the decision maker role that I've just been talking about. And then the judgment then goes on in the next paragraph down that I put on the screen to go on to say and discuss this decision maker role a bit more. And you can see there it says that the building owner and the contractor make their contract on the basis that in those types of matters, the architect or the contract administrator will act in a fair and unbiased manner. And those comments are made from the judgment of Lord Reed. You can also see one of the other judges, Lord Morris, at the bottom of the page, commenting that it's the very nature of the architect's function that involves that he will act impartially and fairly. And so we can see in this case that the broad distinction is drawn between the agency role, in which the engineer acts on behalf of the employer and in accordance with his instructions, and the decision maker role, in which the engineer acts in a fair and unbiased manner or impartially and fairly. And so against that background and context, let's now look at how these principles are reflected in the FIDIC red and yellow books. Next slide, please. And so the starting point under the FIDIC, the current FIDIC contracts, is that except as otherwise stated in the conditions of contract, whenever carrying out duties or exercising authority, the engineer is to act as a skilled professional and shall be deemed to act for the employer. And so we can see that the engineer is always required to act as a skilled professional, and the default position is that the engineer is to act as the agent of the employer, or as it's put on the slide in the contract, is deemed to act for the employer. And so, for example, when the engineer issues a variation to the works, he is deemed to act on behalf of the employer. And this is not surprising, since it is ultimately up to the employer to decide what it wants to be built. There are, however, two very important situations in which the engineer does not act as the agent of the employer. And the first situation is where the engineer issues payment certificates, both the monthly interim payment certificates and the final payment certificate. And in both cases, as we can see from the second bullet point on the slide, the engineer is required to certify the sum that it fairly, the word fairly is very important, that it fairly considers to be due. And so there is a clear duty of fairness on the engineer when issuing these payment certificates. Now, these payment certificates are binding on both parties. And so as a consequence of that, the employer is obliged to pay the sums certified by the engineer. And if the employer pays this amount in due time, the contractor cannot say that the employer is in breach of its payment obligations. It is, of course, having said that, it's of course open to either the employer or the contractor to seek to have the certificate revised in dispute resolution proceedings. But the fundamental point is that the employer's obligation to pay is an obligation to pay the amount certified by the engineer. And so that's where, first example I'm giving you of where the engineer is acting in its decision maker role. Next slide, please. The second situation in which the engineer does not act as the agent of the employer is when the engineer determines the contractor's entitlements to an extension of time and an additional payment. And in this situation, the red and yellow books adopt a two-stage process. First, for a period of 42 days, the engineer is to consult with both parties in an endeavour to bring about an agreement of the claim between the parties. And if agreement is not reached within the 42 days, the engineer has a further 42 days to determine the claim. And we can see this reflected on the side, because you can see in the first bullet point, I refer there to the consultation to reach agreement, the first phase, and then the engineer's determination under the second phase. And then when you have a look at the wording of the text, it then goes on to say, and this is of course quoted from subclause 3.7, when carrying out his or her duties under the subclause, the engineer shall act neutrally between the parties. So the engineer is under a duty to act neutrally between the parties. And then the clause goes on to say expressly that the engineer shall not be deemed to act for the employer when acting under this provision. Now, the duty of the engineer to act neutrally was introduced for the first time in the 2017 books, and the FIDIC guidance notes to those books provide helpful guidance as to what the term neutrally means. So I put that on the slide, and it says the engineer treats both parties even-handedly in a fair-minded and unbiased manner. And I think that is a helpful description of what the duty of the engineer to act neutrally means. But of course, ultimately, the engineer has to make a determination of the claim. And then the question is, well, what does he have to actually produce? And the answer to that is also provided in the contracts, and that is that the engineer is to make a fair determination of the matter or claim in accordance with the contract, taking due regard of all relevant circumstances. And so what do we have so far? He has to act neutrally in making his determination, and that determination must be fair. And then you get the question, well, what does all of that mean? The FIDIC Contracts Guide also provides some helpful assistance, and it explains that the engineer, when making his determination, is required to give and to be seen to give due regard and equal weight to both parties' views, considerations, arguments, and concerns as raised in the consultation process. So that's what he's supposed to do. Then one gets the question, well, what is this determination meant to look like? And the answer to that is also provided. The contracts provide that the engineer is required to describe the determination in detail, with reasons and detailed supporting particulars. So that's what the determination is meant to be. The consequences are also specified. Determinations by the engineer are stated to be binding upon both parties until revised in any dispute resolution process. Next slide, please. Now, whilst the engineer has wide-ranging powers under the red and the yellow books, these powers are not unlimited. Under subclause 3.2, the engineer may only exercise the authority attributable to the engineer as specified in or necessarily implied from the contract. And importantly, as you can see on the slide, the engineer shall have no authority to amend the contract or except as otherwise stated to relieve either party of any of its obligations under the contract. Next slide, please. Now, as I mentioned at the outset, the engineer is retained under a consultancy agreement with the employer, and the scope of services of the engineer under that consultancy agreement may be much broader than acting as the engineer under the contract. And I put some examples on that slide as to what the scope of the engineer's duties under his consultancy agreement might include. I've included references to project feasibility, advising on project budgets and timelines, preparing the design and the bills of quantities under the Red Book, and preparing the employer's requirements under the Yellow Book. Now, when one looks at those broad-ranging functions, one can see that there might be role for and scope for tension to arise between, on the one hand, the engineer's duties under the building contract, and under the other hand, his more broad functions under the consultancy agreement with the employer. And I've given an example there where the engineer is required to recognize a variation under the Red Book. Now let's just assume that the engineer did the design upon which the Red Book contract is based. It might be that a tension then arises with the engineer being reluctant to recognize an entitlement to a variation to correct an error in the design that the engineer himself has prepared. And so one can see, given the broad role of functions that the engineer may be required to carry out for the employer under his consultancy contract, again, there might then potentially be room for tensions in his function as the engineer under the building contract. I've given the example of the Red Book. The equivalent example under the Yellow Book would be where the engineer prepares the employer's requirements and is reluctant to recognize a variation which is necessary to correct an error in those requirements. Next slide, please. Now, a particular area of sensitivity arises where, under its consultancy contract with the employer, the engineer is obliged to obtain the consent of the employer before exercising its power to act as the engineer under the construction contract. And the red and yellow books seek to manage this situation by providing that any such agreement to obtain the employer's consent under the consultancy contract must also be stated in the particular conditions to the construction contract. And so the contractor knows that the engineer is required to obtain the employer's consent. And that's the first paragraph on that slide where I've quoted from subclause 3.2. One can also see from the third paragraph that the employer should not impose further constraints on the engineer's authority. So in other words, that third paragraph is to reinforce the first paragraph and make the point that any constraint or any requirement to obtain consent from the employer is set out in the building contract so the contractor knows what that is. The most sensitive situation of all is where the engineer is required to obtain, under the consultancy contract, the employer's consent before issuing a determination of a contractor's claim for an extension of time or an additional payment. And in the 2017 books, a new provision was included, which is the middle paragraph on the slide. And this is a new requirement which provides that there should be no requirement for the engineer to obtain the employer's consent before the engineer exercises his duty under subclause 3.7, which is the duty of consultation between the parties and then making a determination in relation to any claim by the contractor. And this is a major change from the previous editions published in 1999. So this is a new and very significant amendment that has been made in the 2017 contracts. Now, just to conclude briefly, ultimately, notwithstanding the engineer's obligations to fairly determine the amount of payment certificates and to act neutrally when making fair determinations of contractors' claims, the fundamental question remains: how can the engineer, who is chosen by, paid by, and in contract with the employer, act fairly or impartially towards the contractor? Now, going back to the case of Suklik and Thakral that I referred to, Lord Morris tried to answer this question by saying that the engineer or the architect is not employed by the owner to be unfair to the contractor. Now, of course, that statement is fine so far as it goes, but one has to say that the extent to which that statement is realistic is a matter of much debate. Thank you very much. Back to you, Daduna.
Thank you, Alice. Thank you for this presentation. I'd like to now turn to Husni to build on what Alice has spoken about, to reflect and to share with us how the White Book, the Client Consultant Agreement, reflect the engineer's role in the consultant's scope as it is envisaged in the Red Book and in the Yellow Book.
Thank you, Daduna. In our culture, we start by saying Assalamu alaikum, which means peace upon you all. Thank you for this question, Daduna. How we connect the engineer's duties and role under the construction or works forms of contracts, such as the Red Book and the Yellow Book, and the White Book, which regulates the consultancy services agreement between the client and consultant. Its name is Client Consultant Model Services Agreement, also known as the White Book. Now, the most important clause under the White Book, which relates to this question, is subclause 3.9, construction administration. And it provides important principles that govern such a role to be played by the engineer. So whenever the engineer or the consultant under the White Book, to be more accurate, the consultant is required to play the role of an engineer under the Red or Yellow Books, we need to include in appendix number 1 of the white book, which is called the scope of services, such roles and obligations to be played by the engineer under the white book. And it provides very important guidance on what the role of the engineer might be and how it's governed between the employer and the consultant. So when acting as the engineer under Clause 393, for example, it says, when acting as the engineer, the consultant shall have the authority to act on behalf of the client to the extent provided for under the works contracts. Also, if the engineer's authority is subject to prior approval of the client, this should be clearly stipulated under the red and yellow, which is regulated under Clause 3.1 and 3.2. Also, because FIDIC is an international federation, and we take into consideration both common law and civil law, it says under the same subclause, if the consultant plays a role and to exercise discretion, certify, determine, the consultant shall act fairly as go between the client and the contractor, thus tying in with Sutcliffe and Thankra, the case just cited by Ellis. Of course, also we provided some protections for the consultant. So, for example, 394, the consultant is not liable to the client for the performance of the contract by the contractor. 395, the consultant is not liable to the client or the contractor for the means and methods of construction. One of the biggest risks that we face in the construction industry is that the scope required of the consultant under appendix number 1 does not fully, comprehensively and accurately reflect the scope required of the engineer under the red and yellow. So when we draft the white book, appendix number 1, we need to take good care and a good look at the engineer scope under the red and yellow and make sure that everything is required of the engineer under the red and yellow is reflected in appendix number 1, scope of services under the white book. Thank you so much.
Thank you so much, Husni. I'd like to remind our participants, please put your questions in the Q&A section, and we will have a Q&A section, and we'll try to pick up most of the questions during that time. I'd like to now turn to Lidis. Lidis, speaking from your experience and from the experience of the contractor regarding the role of the engineer, how do you see the technical leadership? How does that intersect with the contractual leadership? What is your thoughts on that?
Thank you, Daduna. And thank you everyone for joining on this webinar. I saw a lot of persons from Latin America, and it makes me very happy to see how the community of FIDIC is also growing in America. Well, regarding your question, Daduna, the engineer is not only expected to understand the technical complexities of the works, but also to ensure that every decision, instruction, and certification aligns with the contract and the applicable law of the contract. So this intersection between the technical and contractual becomes clear with 3 duties that the engineer has. The first one is the technical expertise and oversight of the project. So as we already briefly mentioned, the engineer leads with a team of multidisciplinary professionals. We have professionals in the fields like quality, planning, design, and methods. So for example, if the contractor proposes a change, a switching from board piles to driven piles, the engineer must evaluate whether this change aligns with the employer requirements, environmental constraints, and most importantly, the risk allocation of the contract. It's not just if the new method works or if it's feasible. It's about whether the contract allows it and that this change maintains the agreed risk allocation. So another kind of duty that also gives a clear example of this intersection is the change management, because all projects continue evolving. Change are part of any construction project. So the engineer plays a central role in managing these changes, ensuring that any adjustments are handled through the proper contractual mechanisms which particularly are clause 13 for variations and adjustments, or through clause 20 for contractors' claims. And another example could be the duty of project efficiency. The engineer helps maintain momentum on the project. It provides real-time decision-making on payment certification, on issuing the taking over certificates with the punch list. It carries out inspections, etc. So for example, an interim payment certificate is not only a simple financial transaction, it is a formal certification that the contractor met specific contractual obligations, and it can also reflect the contractor entitlement to additional costs that could have been granted in accordance with the contract, for example, through a determination. So as you can see, the engineer adds a value that neither the employer nor the contractor may be able to provide by themselves.
Thank you so much. Thank you so much, Lidis. I'd like to invite Jonathan as well. I don't see him on the screen.
Here I am. So maybe
Are you here?
On the first screen, here I am.
Liddy spoke about the project efficiency. What do you think, what upstream decisions and project preparation steps are needed in order to make the role of the engineer efficient, to enable the contractors to price accurately, and to enable the engineer to administer the contract efficiently?
Okay, thank you. Thank you, Daduna. Very ambitious question. I would like to first express my gratitude to all the connected people around the world in this webinar. So, well, to answer this question, we have to consider it through the big idea of that a strong engineer downstream, which is able to support the environment in achieving these objectives, is being created upstream. What I mean with that is that in project preparation phases, we are, designing these decision-grade inputs so that later we can consider that impartial determinations are fast and fair at a later stage. First, and for instance, if we refer to ground risks, a typical issue within construction projects, in major transportation projects such as metro lines, we need to issue a credible and detailed geotechnical baseline with some typical conditions, uncertainty bounds, clear triggers for change conditions. So in this context, contractors can price it. The engineer has objective evidence to administer the contract under the FIDIC environment, thanks to the realization of such a credible and detailed geotechnical baseline. Again, I think that engineers must rely, and everybody must rely on interfaces. You know that we are building an interface responsibility matrix and a commissioning dependency map. Who owns every interface, and in what sequence systems come alive? This is particularly true in the railway sector between civil works and systems. Thanks to this approach, we prevent invisible scope gaps and assign every interface in the risk register to named owner from day one. These ownership lines then must be mirrored into contractual arrangements. Third, we need to think about something very essential, which is the outcome-based employer's requirements. We need to set a fit-for-purpose and absence and defect standard with minimum prospective baselines, only where safety and interoperability require it. We can include acceptance criteria, test protocols, as well as measurable sustainability indicators, such as carbon budget with environmental protect declaration factors. Finally, I think that there is a need for true project digital spine with the BIM, with the common data environment, naming conventions, standard communication packages, and specific workflows. The CDE, or common data environment, governs documentation and configuration control, so every determination is auditable, fast, and defensible. So with all of this, we set simple rules for optimizations and design changes as a response to some of our speakers. Then we align contract form to uncertainty with the remeasurements where risk dominates. These current deadlines, employers' requirements, interfaces, digital contract forms make the project priceable, bankable, and administrable. At the end of the day, our job is to produce those decision-grade inputs and push the employer to sharpen the initial need as much as we can. Thank you for that.
Thank you, Jonathan. I turn to Fanny now. Fanny, would you take on the second round of questions? And we'll talk about the sustainability as well and some of the aspects, Jonathan, you've mentioned later on during the webinar.
Yes, sure, Daduna, we can have a second round of questions, and I will first turn to you, Husni. You mentioned it a bit, but I would like to come back on the role of the engineer understood in civil law versus common law jurisdictions. So how is the role of the engineer understood in civil law jurisdictions? And could you tell us more about the golden principles and the upcoming FIDIC services agreements golden principles?
Thank you, Fanny. Thank you so much. This is a very important question, in my opinion, because as we have seen, Ellis has clarified the role of the engineer under the common law, and there's a huge misconception in the industry worldwide that the engineer is only mentioned in common law only, and civil laws do not tackle the role of the engineer. Unfortunately, this couldn't be further from being the truth, because virtually all civil laws address the role of the engineer, however, from a different angle as that covered by common law and using different names. We see the name of engineer as is used in some civil laws, architect engineer, or architect, or some other name that denotes this role in numerous civil law countries. So it is not only the common law which addresses the role of the engineer. And also under all civil laws, we see the dual role of the engineer or the consultant being the designer or the supervisor or both. And even in some civil law countries, we see a regulation of the payment to the consultant if there is a disagreement between the employer or the client and the consultant. So the civil law covers the role of the engineer quite satisfactorily, but maybe in a different way compared to the common law. Of course, the role of the engineer under the works contracts should be viewed through the lens of, under FIDIC contracts, of course, through the lens of the golden principles released back in 2019. And the first and foremost golden principle, GP number 1, deals with the roles and responsibilities of the engineer. The whole balance of the red or the yellow books hinges on the engineer playing a certain role. So if this role is significantly distorted through the particular conditions, this will adversely impact the balance, the contractual balance in the contract. And following the huge success of the works golden principles, we are currently in the process of drafting the golden principles for the FIDIC services agreements. Hopefully this year, it will be released by the end of this year. This is our target, to regulate the relationship between the client and the consultant in the white book and the other services agreements suite, like the joint venture form or the subconsultancy form of agreement. Thank you.
Thank you, Husni. You know, at CICA, we are always pushing for these golden principles to be applied when talking to the clients, but also to the financiers, multilateral banks. So it's great to continue and push for it.
I'm delighted to hear this. Being one of the co-drafters of the golden principles, this is music to my ears. So thank you so much for your position.
Nice. Maybe Elise, you want to add something to Husni?
No, it's just we can continue because we're short of time. Just continue.
Okay, sure. So maybe I will turn to Lydis to hear about the contractor's perspectives. So Lydis, what challenges arise on the projects? What are the key misconceptions about the engineer's authority and duties? And how can it be addressed, according to you?
Thank you, Fanny. So my answer is going to be, I will supplement what Husni and Elise already has said during their responses. So the most common misconception is related to the decision making and fairness, where the engineer is simply seen as an extension of the employer. It's someone who will act in the employer's interest when determining claims, for example. And this perception can be understandable because he is paid and appointed by the employer. However, the FIDIC red and yellow books clearly provide that the engineer has to act fairly and impartially when making determinations. So this is not a suggestion, it is a legal obligation. And as Ellis already showed references to the FIDIC guidance, and Hasni already mentioned about the FIDIC golden principles, I believe that to address this misconception, you can consider two essential things. The first golden principle that states that the roles and responsibilities of all contract participants must remain as intended in the general condition. And it's very important because this principle and the general conditions already provide for an engineer that is neutral, independent decision maker, and he has to consult with both parties to issue fair determinations. From my experience, I unfortunately have seen particular conditions where they alter this balance. So, for example, that the engineer is required to obtain a prior approval by the employer before issuing a determination. And these kind of amendments are the ones who undermine the engineer's independence, and they violate the spirit of the general conditions and of the golden principles. And this, as a consequence, erode the trust in the engineer role by the contractor because it may perceive that the process is biased. So this golden principle number 1 serves as a safeguard against these distortions by reminding us that the general conditions are carefully structured to ensure a fair and balanced allocation of the responsibilities. So it's always advisable to not deviate from this structure. And also, I think that training is essential. Engineers who are trained to FIDIC accredited programs or with contract managers that are trained in construction law are more likely to understand this principle and to embrace the duty of fairness.
Thank you, Lydis, for sharing with us your experience and recommendations. Maybe Jonathan, can I ask you, how do you involve industry early without compromising competition to calibrate employers' requirements and decide the right procurement lot strategy so that the interfaces that you mentioned earlier are coherent and effective from day one?
Yeah, thank you, Fanny. So as you mentioned, as Lydis pointed out, what it's all about relationship. It's all about interfaces. It's all about communication. It's all about getting involved together at the right stage. So we know that today early market involvement or early market engagement within the World Bank perimeter or early contractors involvement, you name it, is actually reality capture and not vendor capture. What I mean with this is that our aim is to turn the transparent market sounding around outcomes and integration. We share scenarios and interface map, then ask what performance and availability can be guaranteed, where are the bottlenecks, which interface drive integration risk, that feedbacks let us, let's say, right outcomes, employers' requirements, because at the end of the day, it's knowing exactly in advance and in a very precise way what should be the employer's requirements without trying to go too far into the specifications. So we have to be as less as we can prescriptive in that way so that contractors may define and propose their relevant offer in line with those specific employer's requirements. Then that project comes with specific lotting. So we tend to split projects around natural boundaries and depending on commissioning dependencies, for instance. In the railway sectors, we are used to split civil activities from system activities. So this is also an example at a level where we try to from time to time merge rolling stock and signaling activities into one single package in order to have some consistent and coherent packages to be considered. But once the project is being divided, we have to consider that into an integration issue, because then we consider that each interface within these different packages must be clearly populated into the risk register and is owned by a lot and mirrored into the contract documents with integration governance, design review processes, interfaces control documents, configuration controls, and synchronized test agenda. So at the end, this is producing, let's say, a favorable context, trying to, let's say, better integrate considerations for contractors since the very beginning of the design of the project at project preparation stages, where the role of the engineer, the good role of the engineer at the downstream level is being created upstream. This is where we are defining responsibilities, acceptance criteria, and defining the conditions for less disputes and so on. It also answers some of the regulator concerns in terms of improving the competition, improving the needs definition, avoiding captive innovation, strengthening sourcing and participation of SMEs, and surfacing obsolescence, schedule, and environmental and social upfront constraints. So all of us, I think that is a kind of a pre-agreed map for responsibilities and actual effective delivery within the context of trying to work together in a very smooth and peaceful environment. Thank you.
Thank you, Jonathan, for your insights. I think it deserves a full webinar, so maybe we will discuss it when we speak about the good preparation of construction projects. It's a very important topic, and we're also discussing with the MDBs about the early market engagement and how we can do it in the best for better outcomes. So now I will, before we move to the questions of the floor, I will turn again to Daduna for a third short round of questions.
I see that we have many interesting questions from the floor, so we'll try to take as much time to address those. But before we do that, I wanted to go back to and Husni to come to you with the question. Ellis spoke about the engineer being paid by the employer, and I think the questions as well come to that respect. So I wanted to hear your view on that topic and what are the safeguards that the engineer is fair and neutral when making the determinations when it's acting in this role.
Thank you, Daduna. As Ellis said, and I have clarified in my under the first question, we have in the contracts and under the law the guardrails and the constraints on the engineer's role being fair and as between the client and the consultant. But do we see this in reality? Unfortunately, in many cases, no. Why? Because lack of understanding of those exercising the role of the engineer, of these guardrails, and what is required of the engineer being fair. And now in 2017, being neutral when issuing determinations between the employer and the contractor. Now, so we need engineers who understand their role and read the red and yellow book and their role under these works contracts and the white book and understand these guardrails. And they should understand that although that they are appointed and paid by the employer, this does not conflict or prevent them from playing the role of being a fair entity as between the employer and the contractor. So we need qualified engineers, and here comes into play FIDIC's QBS, quality-based selection. So the selection of the engineer should be based on quality rather than cost. Cost plays a role, but the main emphasis should be on the quality, the qualifications of the engineer. And now the most recent edition of the QBS that was released by FIDIC, by the way, it's available free of charge on FIDIC.org, all of the guidelines related to QBS, and now it's called cost and quality-based selection because cost plays a role. The most recent version was released in July 2023, and you can download it free of charge from FIDIC. And it says the same thing. Yes, cost plays a role, but the main emphasis and focus when we select engineers on their qualifications. And by extension, their qualifications mean that the engineer understands their role. Another important aspect is capacity building. So we need those exercising the role of the engineer, attend training, or somehow we increase their capacity as engineers to play correctly this role, because it is a very pivotal role of the engineer in the construction contracts under FIDIC. Thank you.
Thank you so much, Husni. You raised the point of capacity building, and yes, it's all about the awareness. We've seen many excellent engineering firms performing the role perfectly, and in some case, if there is not the awareness of selection based on the cost. I'll turn back to you, Lidis. You also mentioned the capacity building. What are your thoughts on that?
Thank you. Well, how we can enhance the knowledge and the capacity of the project participants. I think that in today's market, there are plenty of options where you can learn more about contract management, claims, disputes, but FIDIC already offers high quality programs that are especially tailored to the realities of international construction projects. We have, for example, the FIDIC Academy that offers a range of contract training courses aligned with the FIDIC Red and Yellow books that can be useful for professionals acting for or on behalf of the employer, the contractor, and the engineer. They have introductory workshops that are designed just to be familiarized with the FIDIC suite of contracts, but they also have advanced courses on management, administration of the contract for disputes and claims. And specifically for the case of the engineer, there's also a certification for consulting engineers. And it's not a training course, but it's offered also by FIDIC, and it's designed for experienced consulting engineers who are already working in senior roles. So keeping yourself up to date and keeping learning what's in the market and how the construction industry is evolving, it's always important.
Thank you so much, Lidis, and mindful of time, and we want to take questions from the floor. So last question to Jonathan, and then we open the floor to questions. Jonathan, in 1 minute or so, if you could tell us, we speak about the sustainability, you mentioned it before, but how do you translate carbon resilience and social acceptance into the contract-ready verifiable requirements? And that would improve bankability and don't create the fool for disputes?
Okay, very, very ambitious question. I think that
in 1 minute.
Yeah, okay, but I will not be able to answer this very ambitious question in 1 minute. But well, let's try to give a few, let's say, elements on that. Well, we are all on a learning curve, you know, as it was already mentioned. The context is evolving. We are now setting up some new standards within our project, some new obligations, mostly aligned with the conditionalities for financing on infrastructure projects, where we are clearly need to have, let's say, EPD, environmental product declaration documents associated to measurable impacts. So once that said, how do we go ahead with that? So I was mentioning there is an issue of setting up the measurable KPIs and employer requirements in line with technical aspects and functionalities, but in other terms, we also need to consider it from the sustainability point of view. So it has to be aligned with what the market is able to produce, and that I would like to advocate on the FIDIC Carbon Management Guide, which was recently issued. So I think that within the framework, we're able to, let's say, better consider the objectives of what is supposed to be the green finance and what are supposed to be the sustainability objectives of new infrastructure projects. So I think that within this perspective, there's still quite a lot of things to be done. We need to go ahead with that. We have the possibility to produce some more bankable documentations within work contracts, which could in a way be enforceable without ambiguity. I think that digital discipline is, in that sense, of utmost importance. That's related to the enforcement of high-level common data environment that I was already mentioning, with standard documentation, evidence trails, periodic carbon resilience reporting to link milestones, etc., etc. So I think that is a kind of a path in which we are all involved in, and that we have to learn from one another. So in order to, let's say, improve the understanding and the way that we can achieve those ambitious objectives. Thank you very much.
Thank you very much, Jonathan. I think let's open the Q&A part of the discussion so we can respond to some of the questions. I'll start with the first question, and then Fanny, if you can help me so that we can, I think we don't need the slide sharing. We'll turn to the questions from the Q&A chat. And I'll start from the sequence how the questions came. There is a question asking, how can the engineer remain independent under subclause 3.7 when the employer expects to be consulted before key determinations? Any of you, Husni or Ellis or anyone else would like to address that question?
I'd like to go first because there's an express stipulation under subclause 3.2 in the red and yellow. It says that for the exception of subclause 3.7, the employer can place a constraint on the engineer playing certain roles and functions in such a manner that the engineer requires the employer's prior approval. So subclause 3.7 is expressly excluded from the provision which allows the employer to put a constraint on the engineer's ability to exercise a certain function before the engineer takes the employer's prior approval or consent.
Thank you, Husni, for that response. Ellis, then I think I'll turn to you with the second question regarding how do the panel see the interaction between the engineer making determination and the DAB making a determination. For example, if there is a DAB, what is the benefit of the engineer making determination? The question is from Nick Rugby.
All right, well, why don't I thank you, Duduna. So I said, even though you have the two stages, you've got the engineer making the determination, and then if that is not agreed to, you've got the DAAB making a decision on the dispute. In my view, they have two different purposes. You have the engineer who is there administering the contract. So he's the person that is there day in, day out, actually running the project. So the claims go to him. He has to make a determination of it. That's what he has to do, right? As I see it, then the role of the DAAB is a different role, because there that role is, if either party is dissatisfied with what the engineer has done, they can then take it to a third party body, which is required then to act impartially and making its own decision. And in making that its own decision, they will obviously have to hear what the engineer has to say, hear what the contractor has to say. But I've always seen the two roles as very different. And so it needs to go to the engineer first because he's the person running the job. And if either party is unhappy with that, it then goes to the DAAB, which makes a decision in a short period of time.
Thank you, Alice. Fanny, any questions that you'd like to pose?
Yeah, sure. Maybe I'll take the one from Jan. What is your opinion on a situation where the employer wishes that the engineer's determinations under SC 3.7 would be immediately final and binding? Would this be a good idea to have rapid dispute resolution, or would it be contrary to the FIDIC golden principles, industry best practices, and most all applicable laws which make courts or arbitration as a final resolution mechanism? To complement on this discussion, who would like to take this one?
mean, Pam, do you want me to comment on that briefly? I can comment on that one briefly. I mean, it follows to a degree to what I've just been saying. I'd like to think that the FIDIC contracts do provide for a rapid dispute resolution process, because disputes go in the first instance to the DAAB, which has 84 days to make its decision. And then it's only if one or other party is unhappy with that they then go on to amicable settlement and arbitration. So I think there is actually that process, I'd like to think, is already built into the FIDIC structures. I mean, Daduna, would you like to comment on that?
Lidis, I think, wanted to share.
Yes, thank you. Well, just specifically talking about applicable law, it's important to mention that even if you sign a contract that says that the engineer's determination is final and binding, there could be cases where the applicable law does not apply to that. So it will overrule that clause, and then you will be able to pursue a further instance under the applicable law. So you always have to be careful, and you always have to double check what the applicable law says. Mainly in civil law, I can see this happening.
And if I may, I certainly don't think it would be a good idea to provide that the engineer's determination is final and binding. I absolutely agree with the points made by Lidis about the governing law. But I mean, the engineer is acting under the contract. There has to be a dispute resolution process. I don't think it would be appropriate to have just the engineer being final and binding.
I think that the contract builds the mechanism, and if the parties agree if they are satisfied, it can be final. If not, the contract already provides the mechanisms that can escalate and go. But and the engineer indeed plays the crucial role, as you mentioned, Ellis, being on the site and having the knowledge. And as Lidis was talking about, the technical knowledge and the contractual knowledge, in the best position to provide that, to be the first tier in agreement and in determinations. But certainly there are the other steps that follow if the party is not, the contractor, not satisfied with that outcome. And it's an interesting discussion of the common law and the civil law. We have a very broad question here. I think we will take another webinar of how does common law and civil law influence FIDIC contracts. Maybe we can address that in a very short answer, of course, without going into the details. Anyone, Husni, you'd like to share your view, and anyone else?
Yes, thank you. As I was explaining under the relationship of the role of the engineer and civil laws, in all of the civil laws which follow the French civil law model, the engineer and the contractor are jointly and severally liable towards the employer for what is called the decennial liability. They are liable to the employer for any full or partial collapse of the structure. So this is something that you cannot contract out of or limit the liability. So this should be understood and preferably reflected in the White Book agreement between the client and consultant. Also similar what we call public policy stipulations in civil law countries should be observed under the contract. And I think the same goes for the common law. I'm sure Ellis agrees to this. There are certain matters, whether you write it in the contract or not, from under the law. If it's public policy, it is there. So preferably for those who don't know, to reflect such public policy stipulations in the White Book regulating the relationship between the employer and the client and consultant. Thank you.
Thank you. Fanny?
Maybe can the panel elaborate between engineer being an individual nominated by the consultant versus consultant firm named in the FIDIC agreement between the employer and the contractor? certain jurisdiction, the term engineer is a protected position under law. Can you elaborate on this?
I mean, do you want me to take that?
From
I mean,
MDEN?
I can perhaps take that very briefly. I mean, if one looks at the current forms of the contract, what it talks about the engineer, or if a legal entity, the natural person appointed to act on its behalf. So obviously you always have to have somebody called the engineer, and that can be a consulting firm, it very often is, or it can be an individual. But if it's a consulting firm, there is going to have to be a person who is actually going to have to fulfill that function. It comes down to somebody who's actually going to do it at the end of the day, even if the named engineer is a consultancy.
And if I may add, Alice, by definition, under the red and yellow books, the engineer is a person. The contract didn't stipulate whether it is a natural person, an individual, or a legal person, a firm. So it could be either this or that. However, even if it's a firm or an individual, if there are requirements under the law to obtain a certain qualification or a certification, whether it's an individual or a firm, this should be satisfied.
Thank you, Hosni. There is a question maybe Lidis or Jonathan could respond to. Grateful to explain briefly the contractor's role and inherent risk to identify errors and omissions in scope under the Red Book and Yellow Book contracts. Would any of you like to address that question?
Yes, if I may, where, it's all about, there will be a specific webinar for project preparation, let's say, conditions, but I think that every kind of issues like that may be, or risk may be, let's say, identified and discussed at the upfront stages. When I was mentioning the early market involvement and being in a position to present to the industry the employer's requirements in a very sharp way, because it's always better to have that defined from the very first stage than trying to find some certainty later. So that's the point. So I think that there are different windows in which there is possibility to identify and to bridge some gaps that could be related to risks, to errors. The project is lively. There will be new developments, new designs taking place. But I think that along the way, we need to clearly back, let's say, the FIDIC documentation as part of the story behind the project. So that's definitely the thing that we need to consider in terms of preventing issues like that and considering this kind of risk. But please, Lidis, please consider that from the more legal point of view. Mm-hmm.
Yeah, and at a second stage, after you have your contract already executed, I think that the main difference is that on the Yellow Book, when you after the commencement day, you have a certain period of time where you can scrutinize the employee requirements, and then you can look for errors and omissions. And this is very particular for Yellow Book because you are the contractor is the one that is responsible, bears the risk of design. So you have that opportunity to find any errors or omissions in the employee requirements. After that period, then you become liable, or you are the responsible for the design, which is totally the opposite on a Red Book, because in that one is the employer who bears the full risk of the design. So if there are errors or omissions when you receive a drawing, you identify it, you notify it, and you get entitlement if there is any.
Maybe we have one question for all of you. If you could give one piece of advice to employers, contractors, engineers, funders, and other project participants, what would it be? If Lidis, you would like to start?
Yes, thank you. Well, as I already mentioned, for me, I think it's very important that everybody always keep updating, and that you always that you never stop learning. The construction industry evolves rapidly, and I believe that you should not rely only on what you pick up on your job. I know that practical experience is invaluable, but it's not enough on its own. So when you study, for example, FIDIC contracts, if you are only used to bespoke forms of contract, when you start studying FIDIC contracts, this can help you to benchmark your own contract practices against the international standards. And that's why CICA is always like, it's always pointing out how FIDIC helps to identify a balance in the risk allocation. So you can always use FIDIC as a reference on, is this balance, should the contractor accept this risk or not? So it's not just about building compliance. And I wanted also quickly to share a personal experience. I had also an employer that hired a FIDIC trainer to prepare a training tailored to the executed contract. And it was given to the three parties exactly at the beginning of the project, for the contract managers, the project managers, the construction managers of the employer, the contractor, and the engineer. And it was amazing to see how after this training, the parties were aware of the risk allocation. They knew how to administer the contract. And this project ended up winning the FIDIC Award Project of the Year. And I really believe this was not a coincidence. So I always encourage everyone to keep learning and take all the trainings that are necessary for you to build up your experience and to collaborate on the success of your projects.
Thank you, Lydis. Maybe next time you present this successful case study. Thank you. Husni?
Thank you, Fanny. Golden principle number 1, roles, responsibilities, and obligations. Employer, contractor, and engineer, read the contract, understand your role and the other entity's role, and maintain it. Don't try to manipulate it, for example, in the particular conditions, because all of you, all three of you, will pay a dear price later. Thank you.
Very clear. Thank you, Husni. Helis?
Thank you very much. So the foundation of every successful contract and project is a clear scope of work. Do get that right before the contract is signed. If the employer does not know what he wants and the contractor does not know what it has to deliver, the project execution will not be straightforward. My one piece of advice.
Thank you, Elise. Clear scope of work. Well noted. Jonathan?
Well, I think that everything has already been said. I mean, it's about aligning people, aligning requirements, aligning strategy, and being on the same page with regards to what training, to what FIDIC is offering in terms of applying those different golden rules. So I think that in a nutshell, that will be precise as much as possible employers' requirements, try to avoid further disputes, make sure that engineers are being trained and that contractors can work on interfaces as early as they can.
Thank you, Jonathan. And I will, last but not least, turn to Alfredo for the final recommendation.
Thank you, Fanny, and thank you to everyone to speak today and to attend to this, I guess, very interesting discussion webinar. And my suggestion is the point I've started from. The role of engineers, a role of great responsibility, and please get all the information you can get from everywhere, from the webinar, from the website, from everything, and to be always the most fair and professional you can be acting as an engineer, because this role is really strategic and crucial for the quality of the projects and of the infrastructure delivery. And thank you to everyone.
Thank you very much, Alfredo. Very inspiring words. I will now turn to Daduna to close this webinar. Just say thank you to all of you. Very happy to be with you today. Nice discussion. We will share with you the slides, the replay, and hope to see you at the next episode. And I leave the mic to Daduna for the conclusion. Thank you.
Thank you so much, Fanny. We've had a really interesting discussion, and I'm very pleased to see so much engagement. Unfortunately, we were not able to pick up all the questions, but we will come back with another webinars, and we'll engage with further events and conferences. So please connect with us, and we'll continue that discussion. I'd like to thank everyone, all the participants joining us. I would like to thank our speakers for sharing expertise. Thank you very much, Alfredo, for being here with us today. And Fanny, a big thank you to CICA, to you and Andina, to Yeva, and everyone behind working for this webinar as well from the FIDIC side. And we look forward to further cooperation, collaboration, and future discussions. Thank you, everyone, and have a great rest of the day or night. Goodbye.
Thank you so much. Bye-bye.
Thank you.
Thank you. Thank you.
Bye-bye.
Bye.
Bye-bye.
Bye. Thank you.